matter of the marriage of Jamie Leanne Sundgren and Craig Kelly Swafford, case number 2019 DM 348. Beginning with petitioner, would counsel announce appearances for the record, please?
Good afternoon, Your Honor. Susie Locke on behalf of the petitioner, Jamie Sundgren.
May it please the court, the respondent, Craig Swafford, appears with counsel Matthew Mantilla via Zoom.
All right.
Sorry, Judge, I struggled with the mute button. May it please the court, Brandy Ridgway appears on behalf of DCF, who has an assignment of child support.
Very well. This matter comes before the court at this time, initiated by a motion to modify child support and for other relief filed back on April the 22nd. It would appear that the parties in this case are wage earners. With traditional employers, income numbers should be relatively clear. What issues of dispute still exist, if any? Ms. Locke.
Yes, Your Honor. There is some contest from the respondent regarding additional pay that he receives, specifically bonus pay. Our position is that all income should be included in the child support worksheet for child support calculation purposes. I believe the respondent's position is that the bonus income should be paid on some sort of percentage basis. The parties ideally and previously desired to resolve this dispute. They agreed in a prior order to exchange their income information by February 15th every year, calculate child support, and make a determination as to whether or not there needed to be a modification. This year, when we received Mr. Swafford's W-2, there was an increase that resulted in more than a 10% increase to the bottom line of child support. So we...
All right, guys, buckle up, because this one starts simple, but it spirals fast. What we're looking at today is a child support battle that hinges on a single word, bonus. Sounds harmless, right? Wrong. Because in a courtroom, one word can shift thousands of dollars and completely reshape obligations. The petitioner steps in first calm but calculated, laying out the core argument. Craig's income increased, and that increase crosses the legal threshold for modifying child support. But here's where things start heating up. The real fight isn't about whether money was earned, it's about how that money should be counted. Should bonus income be treated like regular wages or handled separately? What once looked like a routine financial update is now turning into strategic warfare. And just like that, a standard modification case becomes a high-stakes legal showdown.
Started talking about a modification, but it was this bonus amount and the request that it be paid on a percentage rather than included in the child support worksheet that resulted in us having to file a motion to modify child support. So our position is that all income is included for child support purposes, that we proceed with modifying child support inclusive of all W-2 income. And then next year when we receive W-2s again, we determine if another modification is appropriate. So it's that bonus income that's really at issue here today.
Ms. Locke, doesn't the court have authority and discretion to order a percentage share, such as I think what Mr. Mantilla and his client are suggesting to the court?
The court does have that discretion, Your Honor, but it's never exercised it in this case in the past. My client has received bonus income on her W-2 for mentoring. The respondent previously received bonus income from Holly Frontier, now HF Sinclair, and that income has always been included on the child support worksheet rather than paid on a percentage of bonus.
Listen closely, because this is where structure meets strategy. The petitioner's position is sharp and unwavering. Income is income. If it shows up on a W-2, it belongs in the child support calculation. Simple, clean, consistent. But the defense? They're not buying that. Instead, they push for a completely different approach, one that could drastically reduce immediate obligations. They argue bonuses should be paid as a percentage, only when they are actually received. And suddenly, the courtroom splits into two philosophies. On one side, predictability and consistency. On the other, flexibility and uncertainty. What makes this even more intense is the history. Both parties had already agreed to exchange financial documents every year and adjust support accordingly. That system worked until now, until bonuses entered the picture and disrupted everything.
All right. Mr. Mantilla, your response?
Well, Your Honor, the child support guidelines were updated, I think, a year or so ago, and they say that bonuses that are periodically received can be included as part of the monthly income, or they can be paid as a percentage upon receipt. And so in my exhibits, we've got the information showing that when Craig started his job in 2023, he was eligible for a one-time retention bonus, and that was in the amount of $4,000. And so that's what's showing on his end of year pay stub 2024 is the one-time retention bonus. Then he's eligible for what I would call an incentive bonus. And for example, in 2024, he got $246 for that incentive bonus. And then his year to date in this year is $1,776. That's based upon safety, worker safety, customer satisfaction, net operating profit. He works for a manufacturing company. And so a lot of these factors are out of his control. It's not guaranteed, it's variable. And so we are asking that per the guidelines allow that it be paid as a percentage upon receipt. And I've calculated that based on his child support owed, which is $1,068 a month is our proposal. And then his gross income without the bonus is $4,415. If you divide 1,068 divided by 4,415, you come up with 24.19%. And so we've got specific language that I'm proposing the court use, and I've seen it in other orders where that's the way the court handles a bonus, and that way it's fair, because if Craig doesn't earn the bonus, then he shouldn't be expected to be held to that standard of income.
All right. Ms. Ridgway, do you take a position here?
Your Honor, I agree with counsel that the court has discretion whether or not that is included as income or if it is set aside in a percentage ordered. However, it is DCF's preference that it be considered income, mainly because it becomes labor intensive.
Now things start getting serious. The courtroom shifts from theory to numbers. And numbers don't lie, but they can be interpreted. The defense lays out Craig's financial structure piece by piece. A one-time $4,000 retention bonus. Smaller incentive bonuses tied to performance metrics like safety and company profit. And here's the key argument. This income isn't stable. It's unpredictable. It fluctuates. It's influenced by factors completely outside Craig's control. So how do you build a fixed child support obligation on something that isn't guaranteed? That's the question they're forcing the court to confront. Because if the system locks in these numbers permanently, Craig could be paying based on income he may never earn again. And that, according to the defense, isn't fairness. It's risk.
Every year to determine the amount of child support to get a judgment for that amount and then allow for payment of that amount. Kansas Payment Center can't simply process a random payment as an addition to the monthly obligation. It is considered an overpayment because there's not a sum specific until a judgment's granted by the court. So that would mean each year counsel comes in, we, file a motion to grant a judgment in this amount. We have a hearing, a judgment, and then that payment could be made. So it's very labor intensive to counsel and DCF to go off of a percentage.
All right. Mr. Mantilla, I trust that on these performance or other bonuses that Craig would receive, there are withholdings?
He's paid the bonus, and then he would have to pay that as a percentage to Jamie. So he would notify her of receiving that, and he's done a good job so far of notifying her of his increases in income. So he would need to notify her of that bonus.
I don't think you understood the court's question. I'm talking about Social Security and other income taxes that would be subtracted from the gross amount when it's paid to the employee. Is that correct?
Yeah, I'm sure that if he gets a bonus that they're going to count it as income and their human resources is going to deduct it.
So would he be paying Jamie 24.19% of the gross or the net?
It would be the gross amount because his paycheck should show what his gross is.
All right.
But hold on, because the other side isn't backing down. The petitioner fires back with precision. Bonuses aren't new in this case. Both parties have received extra income before, and every time it was included in child support calculations. No exceptions. No special treatment. So why change the rules now? And then comes a subtle but powerful point. In 2024, Craig received bonus income and paid nothing extra in support for it. That changes the tone completely. This is no longer just about legal interpretation. It becomes a question of accountability. If bonuses are excluded now, does he benefit from a loophole? The argument shifts from numbers to fairness, from calculation to principle. And suddenly, the stakes feel even higher.
Your Honor, may I respond briefly?
You may.
The challenge that we're having with the bonus that was received in 2024 is Mr. Swafford is refusing to pay that bonus percentage to Ms. Sundgren for child support purposes, even though it was earned, because he was not ordered to do so at the time. This child support order based off the 2024 W-2s essentially takes that moving forward, takes what he earned in 2024 and adds it to child support moving forward. Annually, obviously, there would be a review as previously ordered of all W-2s and adjust accordingly if that becomes necessary. So our position remains that it should be included for income for child support purposes and calculated moving forward. By way of example, Ms. Sundgren in the past school year was part of a mentoring program that she got extra in this upcoming school year, yet the child support would be calculated based on her income when she was doing the mentoring program.
All right, Mr. Mantilla, what's wrong with Ms. Locke's computation here regarding the income of these respective parties?
Well, first off, it's in our exhibits, he got a one-time 4,000 retention bonus. And the guidelines state that, it should be in situations where a payer receives periodic bonuses. So if it's a one-time bonus, it's not periodic. And so that's the issue here, is she's trying to include a one-time bonus as a periodic bonus, and that's not fair to my client, because he's not going to make that much money this year, because it was a retention bonus. Like, hey, you work for us, you stay here a whole year, you'll get 2 installments of $2,000. And we have the contract in our exhibits to show that it says it's a one-time retention bonus. So that's not fair for him to be expected to earn that every year, because he's not going to. And like I stated, last year he only earned, there's a second bonus, which is the incentive bonus, and he earned $246 last year for that, and this year he's at $1,776. So we don't know.
All right, now the judge steps in, and this is where things get intense. He cuts straight through the noise and asks the one question that matters most. What can Craig reasonably expect to earn moving forward? Not last year, not hypothetically, but realistically. The defense tries a creative angle, suggesting an average between past and current earnings. A projection, a middle ground. But the petitioner shuts it down immediately, rejecting guesswork entirely. Their stance is clear. Use actual, documented income. No speculation, no assumptions. And just like that, the courtroom hits a turning point. Because now it's no longer just about how bonuses are treated. It's about whether the future should be built on certainty or prediction.
We don't know what the numbers are going to be, but he's offering to pay it as a percentage. So he's not expected to earn that if he's not, and then he's overpaying in child support. So it's not equitable to do it averaging his income.
We're about halfway through the year. We're just short of it. Wouldn't it be fair just to take this 1776 and multiply it by 2, Mr. Mantilla, as a reasonable projection as to what his overall bonuses will be in calendar year 2025?
Well, we're talking about manufacturing, so he doesn't have control over that. The bonus is based on 1/3 safety, 1/3 customer satisfaction, 1/3 net operating profit. He works in building the airplanes. He doesn't meet with the customers. So whether there's good customer satisfaction or whether the company's making a profit or not, he doesn't have control over that. So it's really just, he doesn't have any control over this. It's really up in the air.
Well, the issue before the court isn't what he has control over, but what is he reasonably expected to make in calendar year 2025? That's the number we're searching for here, Mr. Mantilla. What can we reasonably project that Craig Swafford's income will be for 2025. In other words, for upcoming months and for the future.
But if that's the way the court's headed, I think we should just average 2024 and 2025 to date. 2024 was at 246 for the whole year. So if we're at 1,076 this way through this year, we could double that and then average 24 and 25, and there's a fair number.
Very creative, Mr. Mantilla. Ms. Locke, your reaction to that?
Your Honor, the parties already considered this very issue in agreeing to exchange W-2s and talk about child support based upon the prior year's W-2. Both parties have supplemental earnings. Both parties' income are subject to bonuses, we're subject to COVID pay.
Now you can feel the pressure building. The defense doubles down on one critical detail. The $4,000 bonus wasn't recurring. It was a one-time retention payment, a single event. And building long-term child support around a one-time spike? That could inflate obligations unfairly. This becomes the core of their fairness argument. Temporary income shouldn't create permanent consequences. Meanwhile, the petitioner keeps things grounded in reality, pointing to W-2 earnings as the most reliable measure. No projections, no debates, just facts. And as both sides dig in, the judge is left balancing two competing truths: stability versus accuracy, predictability versus fairness. And there's no easy answer.
We exchanged W-2s. His showed an increase, hers showed a minor increase. We modified child support. There's no need for any guesstimations. We base it on the last year's actual earnings. This could have been resolved in February by agreement of the parties had it not been for this bonus structure that came out of nowhere that parties have never considered before. So if we want to talk about actual numbers, the actual numbers are in the parties' W-2s. The parties already agreed to exchange those W-2s, and there's no need to make this any more convoluted moving forward.
The numbers in your Exhibit 1, Ms. Locke, your apparently petitioner's revised child support worksheet,
Yes, Your Honor.
Exhibit 1 that I'm looking at, those were the numbers that you built this worksheet upon?
Correct. The W-2 earnings from 2024.
So you believe current child support should be $1,187 a month?
Yes, Your Honor. And the reason for the revision, we adopted the respondent's insurance provisions. We had calculated his insurance slightly different, so we adopted his, which resulted in a modification and a total support requested of $1,187.
Mm-hmm. How much does that differ from your proposed number, Mr. Mantilla?
Let me pull my exhibit up here real quick. Let's see here. My proposed number is $1,068, and that's based upon Craig's income at $52,980. So it's let's see, about $4,500 less. But then we're asking for the bonuses to be paid as a percentage.
About $179 difference a month, Your Honor.
What number did you just say, Ms. Locke?
Here comes the moment of truth. The judge openly acknowledges the problem: uncertainty. These bonuses are unpredictable. They vary, and projecting them into a fixed monthly obligation, that could backfire completely. So instead of forcing a rigid structure, he pivots. He leans toward flexibility, and in a decisive move, he sides with the defense's approach. Bonuses will not be built into the base child support. Instead, they will be paid as a percentage, 24.19% of whatever Craig actually receives. It's a calculated compromise, one that avoids overestimating income while still ensuring the child benefits from additional earnings. And just like that, the entire structure of the case changes.
Approximately $179 difference, I believe. Sorry.
I thought the two numbers were 1187 and 1068. That's 119 apart.
This is, oh, yes, 119. This is why attorneys don't do math in their head. 119, Your Honor. I apologize.
All right. Wasn't exactly my strong suit either. All right. What troubles the court is the uncertain nature of the bonus structure of Mr. Swafford. We would be projecting income for the year 2025, which may be wholly unrealistic, and there very well may be realistic. We don't know. It's the uncertainty and the varying numbers that he might expect to get this year. Again, probably outside his control under most circumstances. The court is troubled by building that into child support income for 2025 when there's really no reasonable expectation that those numbers are accurate. I do understand Ms. Ridgway's, I think, very, very valid point about trying to keep track of what child support is actually owed and what's actually paid, and the court's sensitive to that. However, at least for the current time, the court's going to adopt Mr. Mantela's point of view in this case. It very well could be that the recipient of child support will actually profit from this court's order. If the bonuses are larger than what was built into Ms. Locke's worksheet.
But just when it feels like everything is settled, another twist hits. A workers' compensation payment enters the conversation. And now the courtroom faces a new question. Is this income or something else entirely? The defense argues it's compensation for injury, not true earnings. The petitioner pushes back, calling it income received, plain and simple. And once again, the lines blur. This case, which started with a simple word like bonus, has now evolved into a complex battle over definitions, fairness, and financial reality. In the end, the ruling stands, base support set, bonuses paid as a percentage, and immediate payment required within 30 days. But the bigger takeaway? In family law, nothing is ever just numbers. Every dollar tells a story, and every definition can change everything.
Today, it could result in a greater child support obligation for Craig than what Ms. Locke even proposes. And I truly hope that it's a good bonus year for him and he makes all kinds of extra money. But the court will order him to pay 24.19% of all bonuses received as additional child support in the case, and adopt Mr. Mantela's child support worksheet, which I believe would call for an amount of $1,068 a month. Now, it would appear then that since he's already received bonuses for calendar year 2025, he's now in a position to immediately pay the 24.19% on those amounts received. Mr. Mantela?
Greg, can you do that?
What
It's his proposal.
The bonuses for 2025, can you pay those within a reasonable time? 24.9%?
Yeah.
He says yes, Your Honor.
Okay, what's a reasonable time?
Can you do 30 days?
Yeah.
He says 30 days, Your Honor.
All right, the court does find under these circumstances that would be a reasonable time. And I think it may be important to actually discuss the language to be used in this order. And Mr. Mantela, I think, had a fairly well-drafted provision that he proposed. Ms. Locke, are you familiar with the language of that?
Your Honor, I am, and we would ask that